At 9:14 a.m. Eastern Time this morning, the Special Counsel's Office filed docket entry 397 in the United States District Court for the District of Columbia. The filing is titled Notice of Cooperation Agreement, Marcus Hale. It is 2 pages. It states that Marcus Hale, the defendant's former Deputy Chief of Staff and Chairman of Patriot Capital Group, has entered into a formal cooperation agreement with the government pursuant to Section 5K1.1 of the United States Sentencing Guidelines. Under the terms of the agreement, Hale will provide complete and truthful testimony before the grand jury, at trial, and in any related proceedings. He will produce all documents in his possession related to the 14 offshore entities, the Birchwood Holdings Trust, and the Patriot Capital Group transactions identified in his subpoena, and he will submit to unlimited debriefing sessions with the Special Counsel's investigative team. In exchange, the government will file a motion at sentencing recommending a substantial downward departure from Hale's own guideline range. 2 pages, filed at 9:14 a.m. The defendant's former Deputy Chief of Staff, the man who coordinated sanctions implementation with the Treasury Department from inside the White House, the man whose private equity firm received $47 million in seed capital through the same banking channel identified in the superseding indictment, the man who subpoenaed records connect the defendant's official conduct to his post-presidency financial activity, has agreed to tell the government everything he knows. In 26 years of prosecuting federal financial crimes, I have secured cooperation agreements from over 40 witnesses. The moment a cooperator of this proximity to the primary target signs an agreement is the moment the case fundamentally changes character. Before today, the prosecution was building its case from the outside in, using documents, bank records, metadata forensics, and foreign intelligence. After today, they have a witness who is inside the room. Before I explain what Hale's cooperation means for the trial, you need to understand 4 things. First, the specific categories of testimony Hale is positioned to provide, and why each category fills a gap that the documentary evidence alone could not close. Second, what Hale's cooperation reveals about the pressure the special counsel applied and the personal exposure calculation that forced his decision. Third, the immediate legal consequences for the defendant, including the near certainty of additional charges based on Hale's testimony, the identification of Birchwood Holdings as beneficial owner, and the evidentiary foundation for the sanctions-related counts that the classified intelligence could only partially establish. And fourth, the defendant's response this morning, because within 47 minutes of the cooperation notice being filed, the defendant published a statement that may constitute witness intimidation under Title 18, Section 1512, creating the possibility of yet another charge added to an already devastating indictment. That fourth point is the one that demonstrates the defendant still does not understand the position he is in. I'll continue covering every witness development and filing in this case. Evidence, not allegiance. If you want to follow the cooperation as it reshapes the prosecution, subscribe. Let me start with what Hale can testify to, because the categories are specific and each one is devastating. Category 1, White House meetings on sanctions designations. Hale served as Deputy Chief of Staff for policy implementation from January 2017 through March 2019. His portfolio included liaison responsibility with the Treasury Department's Office of Foreign Assets Control, the agency that administers sanctions designations under executive orders, including Executive Order 13848, the order the defendant signed to combat foreign election interference. Hale attended meetings where sanctions designations were discussed before they were made public. He had access to the classified list of entities under consideration for designation. He can testify about who else was in those meetings, what was said, and whether the defendant received advance notice of specific designations. The leaked defense memorandum confirmed that the classified evidence documents financial relationships between the defendant and entities designated under Executive Order 13848. What the classified evidence shows from the outside, Hale can confirm from the inside. He was in the room when the sanctions were discussed. He can identify the precise dates when the defendant learned which entities would be designated, and he can testify about whether the defendant took any action based on that advance knowledge. Category 2, the establishment of the offshore structure. 5 of the 14 offshore entities identified in the superseding indictment were established between February 2018 and January 2019 during Hale's tenure at the White House. The Cayman Islands accounts at Cayman National Trust Company were opened during this period. The Cyprus accounts at the center of the MLAT evidence were established during this period. Hale can testify about whether the defendant discussed the creation of these entities, whether White House resources or personnel were involved in their establishment, and whether the timing of their creation corresponded to specific sanctions-related intelligence that was available inside the White House. This testimony fills the gap that Judge Albright's immunity ruling identified. Her three-pronged framework requires that conduct be carried out through official channels to qualify for presidential immunity. If Hale testifies that the offshore entities were established using knowledge obtained through official channels but for personal financial purposes, the conduct fails all three prongs simultaneously. Category 3, the Patriot Capital Group connection. Hale founded Patriot Capital in June 2019, 4 months after leaving the White House. The firm received $47 million in seed capital from undisclosed investors through a banking chain that mirrors the chain identified in Count 3 of the superseding indictment. Hale can identify those investors. He can explain the source of the $47 million. He can testify about whether the defendant directed, facilitated, or benefited from the fund's establishment. And he can produce the internal records of the 3 transactions that connect Patriot Capital to Cayman National Trust, Asia Pacific Clearing Bank, and Private Bank Zurich, the same institutions at the center of the indictment. Most critically, Hale can identify the beneficial owner of Birchwood Holdings, LLC, the Delaware trust entity that received the $312 million wire transfer flagged by FinCEN. Birchwood Holdings shares a registered agent and incorporation address with Birchwood Document Solutions, the shell company used to strip metadata from court-ordered document productions. The beneficial ownership of Birchwood Holdings has been sealed under Delaware Chancery Court rules since its incorporation. Hale's cooperation agreement requires him to produce all documents related to Birchwood Holdings' beneficial ownership. If that owner is the defendant, the entire financial architecture of this case, from the offshore entities to the metadata tampering to the $312 million transfer, collapses into a single documented chain of control. Category 4, the document tampering. This is the category the defense should fear most. Hale's cooperation agreement was executed after he appeared before the grand jury on March 12th. His grand jury testimony is sealed, but the cooperation agreement's timing tells the story. He testified. Then he cooperated. What he told the grand jury was apparently significant enough that the special counsel offered him a cooperation agreement the same day. Hale's registered agent, the attorney who incorporated both Birchwood Document Solutions and Birchwood Holdings, is the same attorney who served as registered agent for Patriot Capital Group. That attorney is connected to every Delaware entity in this case. Hale can testify about who directed the creation of Birchwood Document Solutions on January 6, 2026, 12 days before the production deadline. He can testify about who authorized the use of DocScrub Pro to strip metadata from 847 documents. He can testify about who directed the selective truncation of revision histories in 312 supplemental documents. If the defendant personally directed the document tampering through Hale or through the shared registered agent, Hale's testimony converts what has been forensic inference into direct evidence of criminal intent. That is the difference between showing the jury that documents were altered and telling the jury who gave the order. Now, what I'm about to show you changes the sentencing calculus entirely. Hale's cooperation agreement means the special counsel now has a witness who can provide direct testimony on every major element of the case. But cooperation agreements do not just provide testimony. They provide corroboration that transforms circumstantial evidence into proof beyond a reasonable doubt. Before today, the prosecution's case relied on documents, forensic analysis, bank records, and classified intelligence. Each category of evidence is powerful independently. Together, they are overwhelming. But defense attorneys can argue that documents are ambiguous, that forensic conclusions are subject to interpretation, that bank records show transactions without proving intent, and that classified evidence is unreliable because the jury cannot evaluate its sourcing. Hale's testimony eliminates those arguments. He is not a document. He is not a metadata signature. He is a human being who was present, who participated, and who will sit in the witness chair, raise his right hand, and tell the jury what happened. Wait, it gets worse. Because the defendant's response this morning demonstrates a pattern that the prosecution will use to devastating effect at trial. At 10:01 a.m., 47 minutes after the cooperation agreement was filed, the defendant published a statement on Truth Social. The post read, and I'm quoting from a screenshot preserved by the special counsel's office and filed as an exhibit to an emergency motion at 11:30 a.m. Marcus Hale is a traitor and a liar who was given immunity to make up stories. He was a low-level staffer who had no access to anything important. His so-called testimony is fabricated to save himself. People who betray trust face consequences, everyone remembers. The special counsel's emergency motion requests that Judge Albright find the defendant in violation of the modified gag order issued on January 19th. The motion argues that the statement constitutes witness intimidation under Title 18, Section 1512, subsection B, which criminalizes the use of intimidation or threats to influence the testimony of a witness in a federal proceeding. The phrase, people who betray trust face consequences is, the motion argues, a threat directed at a cooperating witness whose testimony is material to the prosecution. The phrase, everyone remembers, is an implicit warning to other potential cooperators that disloyalty will be noted and punished. In court, this is called consciousness of guilt expressed through retaliatory conduct. Outside court, it means the defendant responded to the most damaging cooperation agreement in his case by threatening the cooperator on a public platform within 47 minutes of the filing. That timing and that language will be presented to the jury as evidence that the defendant understood the significance of Hale's cooperation, that he viewed it as a threat to his defense, and that his immediate instinct was to intimidate rather than to address the substance. I prosecuted a RICO case against the Genovese family in 2003, where the primary target issued threats against cooperating witnesses through intermediaries. Those threats became count 14 of the indictment. The jury deliberated for 3 hours on the underlying charges and 22 minutes on the witness intimidation count. Conviction was unanimous. The threats were the simplest evidence in the case because they required no financial expertise, no forensic analysis, and no translation of complex transactions. The jury understood them immediately. Threats are universally comprehensible, and the defendant just made one in writing on a public platform 47 minutes after the cooperation agreement was filed. This is the part that kept me awake last night. Because Hale is not the last cooperator, he is the first domino. Cooperation agreements and complex federal prosecutions create cascading pressure on every other individual in the defendant's orbit who faces potential criminal exposure. The dynamic is mathematical, not emotional. When the defendant's former deputy chief of staff, a man who sat in senior staff meetings in the West Wing, who coordinated directly with the Treasury Department on sanctions policy, and who founded a private equity firm that transacted through the same banking chain identified in the indictment when that person cooperates, every other associate in the network must immediately recalculate their own legal position. The registered agent who incorporated the Birchwood entities Patriot Capital and the offshore trust structures now knows that Hale will testify about who directed those incorporations and for what purpose. That attorney faces potential charges under Section 371 for conspiracy and Section 1519 for obstruction if Hale's testimony establishes that the incorporations were designed to facilitate fraud or conceal evidence. The financial advisors who manage the offshore accounts in Cyprus, Singapore, and the Cayman Islands know that Hale will identify the specific transactions they facilitated and the instructions they received. The members of the defendant's legal team who are referenced in the leaked memorandum's litigation continuity group, the faction that advocated continued defiance despite the attorney's own assessment that the strategy was failing, must now consider whether their advice to continue resistance constitutes obstruction of justice in light of the evidence Hale will provide about what the defendant knew and when he knew it. I prosecuted the Abramoff lobbying scandal in 2006. Jack Abramoff's cooperation agreement was filed on January 3rd. Within 90 days, 4 additional individuals entered cooperation agreements. Within 12 months, the total reached 11 cooperators. The pattern is consistent across every complex federal prosecution I have observed. The first cooperator breaks the seal. The second follows because the first has already provided the roadmap. The third follows because the evidence from the first two makes resistance mathematically irrational. By the fourth, the question is no longer whether to cooperate, but how quickly cooperation must be initiated to receive the maximum sentencing benefit. Tell me in the comments, based on Hale's 4 categories of testimony I've described, which category do you believe will be most damaging at trial? The sanctions meetings, the offshore entity establishment, the Patriot Capital connection, or the document tampering directive? I read every response. I read Dutz. Here's what happens next. Today, Judge Albright will rule on the special counsel's emergency motion regarding the defendant's Truth Social statement. If she finds a gag order violation, additional contempt charges will be added to the existing criminal contempt proceedings. This week, Hale begins unlimited debriefing sessions with the special counsel's team. Those sessions will produce a proffer statement that the prosecution will use to prepare its trial presentation and potentially to seek a second superseding indictment, adding charges based on Hale's testimony. March 19th. The D.C. Circuit hears oral argument on the immunity ruling. The defendant's own leaked memorandum concedes a high probability of affirmance. Hale's cooperation strengthens the government's position because his testimony provides the direct evidence of personal, non-official conduct that Judge Albright's 3-pronged framework requires. March 27th. The Senate Intelligence Committee's 30-day review expires. Hale's cooperation agreement, filed on the public docket, confirms what the committee has been reviewing in classified form. Financial relationships with sanctioned entities that the defendant's own legal team described as unexplainable by legitimate business purpose. April or May, the trial. And the prosecution's witness list now includes a cooperating insider who will walk the jury through every element of the case with the authority of someone who was in the room when the decisions were made. The most powerful evidence in any criminal trial is not a document, a bank record, or a forensic analysis. It is a human being who was there, who participated, who chose to come forward, and who sits in the witness chair and tells the jury under oath what the defendant said and what the defendant did. Marcus Hale is that witness. No one is above the law. That principle was tested through 14 months of defiance, through document tampering, through appeals, through contempt, through $2.7 million in sanctions, and through a pre-signed arrest warrant. It held. And this morning, it was vindicated by the cooperation of the one person closest to the defendant who decided that the truth was worth more than loyalty. And that decision, made quietly in a federal building before the morning was over, has ended this case in every way that matters. Subscribe to follow the trial preparation as Hale's testimony is integrated into the prosecution's case. I'll be here when the D.C. Circuit rules and when the trial date is finalized, and based on the full arc of this investigation from the first subpoena to this morning's cooperation agreement, the defendant's strategy did not just backfire. It produced the very outcome it was designed to prevent. And the witness who will deliver that outcome took the stand because the strategy's own architect wrote in a memo that the evidence could not be explained, and the witness read the same evidence and reached the same conclusion.